are going to the next important topic under CLD, which is ADR mechanism. Okay. This ADR mechanism, if you see, you all know that we have arbitration, we have conciliation, mediation, and also we have Lok Adalat. You all know about it. But let's see the previous year questions. How, like, frequently the questions appear from this topic. It is a very, very important topic. So look at the previous year analysis. I think the video is visible. That is, the questions are visible to you. Now, coming to 2025 to 2023, unfortunately, we don't have this a question from this topic. But this reminds us that it can be a probable area to be asked in the upcoming mains. It is an important area and have not been asked for past 3 years. So it will be almost 90% in your upcoming mains. So look at this. They are asking about emergency arbitration in 2022 and specifically about Section 8 of the Arbitration and Conciliation Act. And they are talking about arbitral award and appeal and all those things in 2020. And 2019, if you see, they have asked 2 questions. One is about Legal Service Authorities Act and other is about whether this arbitration method is proper, like that. And if you see 2018, there is 1 question. 2016, there'll be 2 questions asked. And 2015, 2 questions asked. You may wonder why 2 questions from the same topic. It is not like that. We have Arbitration and Conciliation Act under your law of contract. Okay, so in mercantile law, that is the law of contracts, you have a last topic called as Arbitration and Conciliation Act separately. So specific questions like what is the proper scope of Section 8 and or what is the appeal that we can go from the Arbitration Act or specific question about conciliation is from the contract law point of view. Now we have ADR under the under the CLD also. So we are going to cover except Arbitration Act. So those things are covered under your CLD. When we do contract law, we will be doing separate act specifically, which is the Arbitration and Conciliation Act. So if you talk about the contract law perspective, that is Arbitration and Conciliation Act, again, I'm telling you, section specific areas are repeatedly asked. So you leave all the section specific question that is previously asked because we are going to cover in the upcoming class. But today for CLD regarding the arbitration mechanism, they are asking generic questions. So today's class, we will be dealing with very general areas which are repeatedly asked in your UPSC. That is our concern. So if you're going to sit and cover each and every section of your NALSA, National Legal Service Authority, or every section or everything about the conciliation, you're not going to score more. Only areas which is repeated, you cover, you're going to score well. That's what we are going to do today. So starting with the ADR mechanism, usually UPSC is keen to ask what is actually an ADR. What are the advantages of your ADR mechanism? This is a very simple question. So your competitor is also going to write a good answer. Make sure that you stand out. For that, you need all these proper points. You cannot go more philosophical and write more general points, right? Try to touch the realities of why ADR is advantageous. That makes sense. Now coming to the point, what is ADR? Its full form is Alternate Dispute Settlement Mechanism. Alternate Dispute Resolution. Okay, that's what it is. Which means outside court settlement. It is a settlement of dispute outside the court. That's what is ADR. Next, whether we have found an ADR to replace the court system? No, there is no question of replacing the court system. It was created only to supplement the court system because you all know for what judiciary is famous for. It is famous for only pending cases. Okay, so like that, in May 2022, we had this data that 4.7 crores of cases are pending. So you say there is a massive backlog of cases. And also, if there is delayed justice, it is denied justice. Of course, it is denied justice. So you talk about that also. And when you talk about delay in cases, it is not only because of our rules and procedures. Although we have a timeline, 30 days you file the written statement, 45 days you give the judgment and all we have. POXO case you finish off in 6 months. Yes, we have 138 cases finish off in 6 months. We have all the timelines. But where is the human resources? For the millions of people, the judge ratio is very less, very poor. You have one judge for 1 million of people. How can that can be done? Okay, the ratio, the recruitment is not okay. You have Supreme Court, and I think this is the first time our Supreme Court is in full capacity. That is, all the number of seats of judges have been occupied. Only 33 or 34 judges for the entire India. So the ratio is not proper. For all these reasons, they innovated a new area which is called as ADR. So what are the positive advantages of this ADR? It is less expensive. If you go to court, we have to pay court fees. Many people think that court fees is some 10 rupees or 20 rupees stamp that we stick in our wakalat and all. No, it is not that. If you're going to get an injunction or you're going to get a declaration of title, you are going to pay at least like some 6, 7, 8, 10% of your property's value. And in case your property is valued some 10 crores or something, how much you have to pay? Like that, you are not able to pay all those court fees. In a litigation, it is not that only court fees. What about advocates fees? In case you're going to get a very senior advocate or a person who's advocate on record, they will be charging for per session and per appearance. What you're going to do? So circumvent all these points. It is less expensive. Okay. Next, less time consuming. We all say a civil case can run for 10 years. I bet you even a criminal case is running for 10 years nowadays. So what happens to a civil case? If I put a case today, my granddaughter is going to get the degree. You can say like, ma'am, you're also in law field. Why are you telling this? But certain truth cannot be hidden. That's why I'm telling. So ADR is less time consuming. That is another point. Next, it is free from technicalities. I'm really worried about these technicalities. You see, the person will win the case in the trial court. They go to the high court, still they win. And the Supreme Court, first a regular bench will approve and a higher bench will reverse it. He has won in all three courts. And finally, the higher bench in Supreme Court will overrule just for a small technicality. Okay, so that will not happen in ADR. We are not so concerned about technicalities. Okay, now parties are free to discuss. You can tell me that even in court, in a trial and all, the parties are having umpteen number of opportunity to express themselves. No, it is not like that. They, if in a chief, you are expected to answer what your advocate to you, and also in cross, you have to be very careful that you don't drag the case. It is not like that. See, even in family, we need a place to sit together and talk with each other, right? So that place will be your ADR mechanism. The parties can freely discuss what differences they have, whatever opinions they have without fear, and disclose everything which they will not disclose in court. So they can talk and facilitate their own settlement. Next, parties have the feeling that they are not losing. We all know in a case, one person will lose and the other person will win. That's what happens. But in ADR, we can have a win-win situation. Whatever things I can adjust, I will adjust. And whatever things you need, you can quote and we can agree, come to a mutual agreement. So both of us don't lose, both of us wins. Okay, that is the criteria in ADR. So you explain all these things in the advantages and you also give the reality in the conclusion. What is the reality we will be seeing? See, if they ask advantages, you talk about the advantages in the body and in conclusion, talk about the disadvantages and talk about way forward. What can be done to solve all these disadvantages? In case they are asking disadvantages, you do the corollary. That is, you give the advantages in the conclusion. Okay, like that we do. Now, coming to the history of ADR mechanism, we all think only after the Arbitration Act and the CPC Section 89, we are learning about this ADR mechanism. No. Everybody who sees a Tamil film or also some old Hindi films, you will have a Gram Panchayat where the person will be telling what is right and what is wrong. Even in our Upanishads, we had this ADR mechanism, alternate dispute settlement. You don't go to King's Court always. You can settle with a small arbitral body which is called as puja. Puja is for the traders, Srini is for the artisans, and Kula is by the family, tribes, and the caste. You know, right? If there is a problem in the family, and if at all the bride or a bridegroom, or at least the husband and wife doesn't live together or properly, they have some problem. In my mother's time and all, they used to go and complain to some elder in the family, and you know that elder will be the most sick person in the family. That is different. So they have this mechanism where they can solve within their caste, tribe, and everything. So this was the history and in India. So that you can mention in a single line. Next, what are the legislations and statutes are there to implement this ADR? First act is your Arbitration and Conciliation Act, which we are not going to deal today because we have a separate class, separate 1.5 hours to deal with the areas which is exactly that is going to be repeated in your upcoming meetings. So we will leave that alone. Next, we have the Legal Service Authorities Act. We are going to deal that today. Specific areas repeatedly asked. Next, section 89 of the Civil Procedure Code. Very, very important. If you are a law student, you must know this. If you're not a law student and preparing for UPSC law option, again, you must know this. Section 89 of the Civil Procedure Code. So now, what this section 89 says, you all very well know, civil court is swamped with the cases and the judges are all going nuts. That's what is true. So every case need not be settled in court. So if the parties or the court feels that there appears some element of settlement that the parties can accept, then what the court will do, the court shall, that is mandatorily, formulate some terms of settlement and say that, see, these are the problems between you two. So you do the settlement or something, some hints like that. And it will ask the party to go for any of this ADR mechanism. It can be an arbitration, conciliation, judicial settlement like Lok Adalat, and also mediation. So anything which is suitable, that like that, see, I told you, right? Any of this can be done. So it has elaborated as well. So it can go for arbitration, conciliation, and follow the Arbitration Conciliation Act. It can ask the person to go for Lok Adalat, which is governed by the National Legal Service Authorities Act. Section 20 is linked with Section 89. Next, it can call for judicial settlements and also mediation. Under Section 89, there is a good question which is asked, not in UPSC, generally they will ask, that is, whether it is mandatory. Of course, it is mandatory, but there are certain areas which is excluded. There are civil areas which will have criminal color, which cannot be compromised. Those areas is not open for Section 89. But usually they will ask the court shall send the parties for any ADR mechanism. They will go there and they will get a certificate that they won't agree for the ADR or something, and they will bring back to the court. That happens. So it is almost mandatory. So let me tell you now, what are the areas that are very common for this ADR mechanism? Which cases are commonly sent for ADR mechanism? That is all commercial, trade related, contract related cases. It is all private right. Once upon a time, you both were business partners. Once upon a time, you were in good terms that you entered into a contractual relationship. What happened now? Come, I will make you sit together. We will come out with some settlement. So those type of issues like dispute relating to specific performance, be it a supplier or a customer, be it a banker or a customer, mostly these SARFAESI acts, which help you to reclaim the balance loans and all, they go for Lok Adalats. Okay, because if you push a person, hit a person, and somehow you strangle the neck to get the money, that's not going to happen. If you're going to sit in terms with the person and negotiate and get some amount of money, that is useful. Okay, like that. Next, developers, builders, customers, landlords, tenants, even insurances and all, they can sit and solve the problem. Next, there are cases which will arise from strained relationship. Some relationship like a maintenance, custody and all. See, maintenance and custody are very, very serious. Once upon a time, they were in a good relationship. So if they can sit together and solve the issue, and if the person is accepting to give some type of maintenance for their own children, that can be done. Okay, so those cases also they go for negotiations, especially disputes between partners and all those things. And also, like certain relationship will need a continuance. Even after the dispute, the relationship will continue. Like that, if you have any dispute with your neighbors, yes, it is a dispute with your neighbor where you can sit and talk together because your house is going to be right there. You're going to continue as neighbors like that. If there any continuation of pre-existing relationship that's going to happen between, that is the dispute between neighbors for any easementary right, encroachment, nuisance, or any dispute between the employer and the employees or some associations and apartment association and all those stuff, it is a good area where uh, compulsory Section 89 will be used. Next, all cases relating to tortious liability, because tortious liability is a civil dispute, right? We all claim only for compensation. It is not a criminal dispute. So there also you can go for negotiations. And consumer disputes are quite famous for negotiations. They are also allowed for all ADR mechanisms. But there are areas where ADR is not applied, which will have a criminal color and also which is not compoundable. Certain areas, which is very, very serious, ADR will not be applied. And in cases of fraud also, mostly ADR will not be applied. Now coming to why do we need ADR? We saw the advantages of ADR. That's why we need ADR. That was our first slide. But we have a Malamuth committee recommendation, which is the 222 report, which suggests that we need ADR for these reasons. So apart from giving all the points on why do we need ADR, you give a report based points that is going to add more marks. So what is the main thing? He quotes like this: man is not made for law, but law is made for man. But it is all acting otherwise. Everybody is working for law, everybody is working to pay taxes. That's what is happening. But the point is, man is not made for law, but the law is existing for the entire society's good. So what is the point? If you are making any complex system like courts, costly, which is very, very hard for the poor persons, for that we have ADR mechanism. Now, you can ask me a question whether ADR is helping the poor person, whether that poor person is able to afford an arbitrator, conciliator, mediator. No, that's why we have the NALSA Act, National Legal Service Authorities Act. Lok Adalats are conducted, so they cover the poorer section of the society as well. Now, coming to the opportunity of justice, yes, they are poor people. They have no proper access to justice, and there is no good people like Husainara. This lady, I forgot her name. Her name is Kapila Hirangini, or like who's Traffic Ramasamy, or MC Mehta, who's like knowing the sufferings of the people and putting a pill. We don't have that person. You need not be staggered. You can go to Nalsa. Okay, that is also done. Next, to provide judicial and non-judicial dispute resolution mechanism is the proper work of a welfare state. Any welfare state must work for the benefit of the society. So if the society must be enriched, they should have a judicial system. But since the judicial system is overburdened, they should have a recognized non-judicial means of settlement. It is not something which is not recognized where every person who is in power will be abusing the other persons. No. If we don't recognize this non-judicial methods, then there'll be sprung up a lot of small mushrooms. If they have power, if they have might, they go for the right. Might is right. Then that forest rule comes into picture. Animalistic rules comes into picture. Okay, that's why they are recognizing institutions and making it accessible. Next, all these things you explain. And then we go to the ADR mechanism. What are the ADR mechanism? We have given the names, you all very well know, so we are skipping this. And we have a case law where they will be highlighting an important point. That is, if you go to the preamble, the Constitution promises certain things, which is justice, which is a social justice, economic justice, and a political justice. If I have to stand in a queue all my life for some 30 years, 40 years to get that particular justice, whether it is justice, it is injustice. That's why we needed a time-bound method for deciding the disputes. So this was even approved by the Privy Council in this case law, where they approved a dispute which was sorted by village panchayat. You have to remember, village panchayat, most of the village panchayat will be corrupted if they are institutionalized nowadays in NALSA, Lok Adalat and all. You cannot corrupt, it will not be more corrupted, because who is sitting in the Lok Adalat? It will be that first instance court judge, the JM or the Munisif. He is going to go and, JM not mostly, the Munisif will be going and sitting in the Lok Adalat. This is the judge again. He'll be acting as a normal person who will be talking with everyone, allowing the other persons to talk and come up with a settlement. Okay, that can be done. So even a village panchayat decision was approved by the Privy Council. That also you can use it for the introduction. So now, as we know, as we have got little idea about what is ADR, we are diving into the question. We are going to start with the 2019 question. I want someone to read this. Who can read this? Bala sir, would you like to read it?
Yeah, okay, ma'am.
Yeah.
Alternate dispute resolution mechanism as provided under the Legal Service Authority Acts 1987 has played an pivotal role in dispensation of justice to the needy persons. Explains with the help of legal provision and case laws.
So basically, they are asking the advantages and positive points about the Legal Service Authorities Act. That's all. So we are going to see what is Legal Service Authority Act, what is the idea behind it. So Legal Service Authority Act is established to create Lok Adalats, that is mediation and arbitration for the poor people. I don't have money. I cannot find the arbitrator. I cannot pay money. I don't have money to find any institution. I go to NALSA. They are going to conduct Lok Adalat, where judge is going to be my mediator or the arbitrator, and he's going to solve my person. That's what practically is NALSA. Okay. So from where we get the inspiration, which article has given this inspiration is from Article 39 capital A, talking about equal justice and free legal aid. I have money, I go for arbitration. I am a big corporate, I go for arbitration. No, I don't have money, still I'll be able to have an arbitrator. I'll be able to have some person who's mediating for me. That's where free legal aid and equal justice is called for under Article 39A. So we need this NALSA Act. And you know that it was brought about by 42nd Amendment 1976. And we have the act which came into function by February 1998. If you know this particular function, it started function by 1998. That is totally enough. Not much needed. Now coming to the act, it says that free and competent legal service is needed for these sections of the society. So for whom NALSA Act can be beneficial, that class of persons is given under Section 12. So any member of the scheduled caste, member of a scheduled tribe, or a victim of human trafficking, like beggars or all these people, how they are going to have money, they can go for NALSA. And next, women or child, person with disability, or person in the custody of any industrial workman, victim of any mass disaster, like we got this tsunami disaster and also this Wayanad, Kerala landslide. We have Uttarakhand floods, Assam floods, and all those people. And anybody who are victim to violence, caste atrocities, and all those things, and person with annual income less than which is specified under this particular law. It will be specified by the central government as well as the state government. So if your annual income, family income is below that amount, you can go for NALSA. They will have an advocate to fight for you, or they will amicably settle your problems. Okay, that can be done. So what is the total idea of NALSA? They will be organizing Lok Adalats, a legal system which will promote equal opportunity basis, that bargaining power. Say, for example, you have got a loan from ICICI. Yes, ICICI Bank is quite powerful than you. Maybe you are a small person who is having a petty shop, and you have got a loan for some 20,000 rupees, and now they are asking some 1 lakh rupees. why you can say that it is a nationalized bank, ma'am. Why they are going to do it? See, nobody is against ICICI. I'm just telling. They are doing also. Okay. So you can ask me, it is a nationalized bank. How they can do it? They are doing. They will have the interest rate and all. And whether that single person can go against ICICI, that is not possible. But if he is going to Lok Adalat, the judge will be sitting there and he will be seeing the data, whereas the statements are given, how much interest percentage is calculated. If it is all wrong and also if it is correct and the other person is not able to pay, they will come to a settlement that at least you pay the 10,000 that you got, which is win-win for ICICI as well as the person. Okay. Equalizing the bargaining power. That is also done here. Okay. Next, we have Lok Adalat from the taluk level, taluk to district, district to state, state to national. Like that, we have the separate tiers, which we'll be seeing now. And they also conduct legal, legal aid clinics where the advocates from that particular bar association will be participating and they will be even going to jails, observation homes, juvenile brothel homes, and all those areas where they'll be, I told you, right, from the bar association they'll be going. So there'll be panel of lawyers, paralegal persons, volunteers from the NGO and all will be doing it. I also had a chance of visiting when I was a final year student. Okay. So it'll be nice fun. If you have opportunities and all, maybe you people cannot go because you are with serious in preparation with UPSC. Okay. So you can hear from your friends. Now coming to the other point, we have a mobile app for NALSA launched. So even from the mobile app, you can contact the person and know about the camps when they are conducting. And also every high court will have a separate building. We also have in Madras High Court a separate building for National Legal Service Authority. Okay. There also you can go and get help. So all these things are given. Apart from that, there is a concept called as Nyaya Bandhu under section 12. See, we have spotted people under section 12, right? So there are a panel of pro bono lawyers and they are registered panel with the bar council of each state and they will be providing free legal services. That also is done. And there is another option called as tele laws where there will be community service centers established in each panchayat where lawyers will be volunteering to give free advices. But these two, whether you ask me whether they are working well, it's so, but we do have post in NALSA and all, legal service aid and all. We have a lot of defense counsel which have been listed and people are making use of it. It is working at least. Okay, we have that. Now coming to the organization setup of the NALSA, which is quite important. Only when you know this, you can answer with clarity. First, you have the National Legal Service Authority established under Section 3. What it will contain? It will have the patron in chief. Who's the patron in chief for India? Is our Honorable Chief Justice of India. So next you will have the executive chairman, who is some senior most Honorable Supreme Court judge. Next you have member secretary, which will be a district level judicial officer. So see, what is the idea of NALSA? This National Legal Service Authority, they are going to oversee the work of the state as well as the district and the taluk level. So we have such type of secretary. So first you have CJI, next you have the senior most Supreme Court judge, next you have the member secretary, a judicial officer. Next, apart from NALSA, you have a legal service committee in the national level, legal service committee. So this committee will have the chairperson who is a sitting honorable judge of Supreme Court and secretary from additional district judge level, not district judge level, who will be an additional district judge level. So they all will be coordinating together. Next, you have the state level authority, which is State Legal Service Authority, established under Section 6. And what it consists of is that patron in chief in the state level. So see, for judicial service appointments and all, in judiciary, when I go see their appointments, swearing and all, first line they will sell like, but today we have patron in chief appointing the following judges, take the oath, like that. So patron in chief for the high court is the chief justice of that particular high court. And next you have this judges of, that is chairperson will be the some senior most judge of the high court. And next you have a member who is a district judge, district judicial level officer. Okay, same. You have the same pattern for the Supreme Court, that is national level, as well as for the state level. That you have to know. Next, for the state level also, we have a legal service committee, which will again have a high court, sitting high court judge as a chairman, and secretary will be an additional judge of district level. Okay. Of state level, we have the district legal service authority at the district level, and it will contain a chairperson who is a district judge, and the secretary will be a civil judge officer, which will be a civil judge, senior civil judge, or a junior civil judge division, depending upon the state. Okay, so chairperson and the secretary will be there. Next, you have the taluk level legal service authority, where the chairman will be the senior most judicial officer in that particular taluk. Okay, so you have 4-tier system. First one is the National Legal Service Authority, next state level legal service authority, district level legal service authority, and finally, which is the taluk level legal service authority. So what are functions of these legal service authority is given here in section 4. So establishment of National Legal Service Authority, section 3, their functions is given under section 4. So what are the function? They lay down the policies for the entire legal service working. What all 4 system must do. What is their policy? That is done only by the National Legal Service Authority. Next, they have to coordinate all these 4 states, 4 levels, state level, district level, taluk level. And they must monitor the functions of these. We may think that judges are doing only judicial work, but see how they are having all administrative works as well to check on all these legal service authorities. Next, they must encourage negotiations, arbitrations, and conciliation, and allocate funds till the district root level. Okay, what funds are allocated everywhere? That also should be done by the National Legal Service Authority. Next, what are the functions of your state level authority? That is given under section 7. Establishment is 6 and their function is 7. Okay. Now, they will give legal advices and they will conduct Lok Adalat. Yes, in High Court calendar, if you download, you will have a special area which day is selected as the Lok Adalat. At that time, usually lawyers will not go and represent. Okay, because we are always representing in court and we are talking all laws, and the judge is really pissed off because of us. So mostly they don't allow, but certain times they will allow. What we will do is, even in my office, what we will do is, we will go and ask the client to come. The client may be wealthy. She will be having very pretty earrings, diamond earrings, rings and all. So what we will say, put a dress which is not at all flashy, which is a normal dress that you wear at home. Okay, so wear a dress like that, and don't put any jewelry, don't put any makeup. It is good even if you don't wash your face. You just come there, I will tell you what to tell. Like that, we will try and see these all that we do for a client's benefit. Just I am telling. Okay, so they at that particular day, every state will be conducting the Lok Adalat. Yes. So it is the function of the legal service authority to conduct particular dates Lok Adalat. And next, to undertake preventive and strategic legal aid programs. It will be done also even in Saturdays and Sundays. Sometimes your district judges and all will be called. They'll be working all day and also Saturday and Sunday sometimes to do all these legal service authorities work. So that is another function. Next, you have section 10, which talks about the function of the district level legal service authority. They must coordinate with the local taluk level and organize Lok Adalat. So Lok Adalat organization is the core work. And what is the core work of the National Legal Service Authority? To coordinate all them, monitor all this and allocate funds. And you have to formulate a policy. So these are the main works of the top head. Next, taluk level. You always know what is the thing. They have to coordinate the activities in the legal services that is done particular in their taluk level. And also they will organize a lot of Lok Adalats. So maximum Lok Adalat would be conducted once in a month. And I told you, right, the national authority will be monitoring. So each, be it a DM, district municip, or it is happening in the district court or in the high court, the persons, that is the judges, must show highest disposal. So practically, if you talk about Lok Adalat, we may think that each party will be allowed to talk for hours and the judge will sit quietly and give a remedy. No, 3 minutes, 2 minutes, they will dispose of. If they dispose of some 100, 120, 25 cases, they will get a good performance from their higher officers. So that is one black area disadvantage that we are going to quote, but we will quote later. I think the time is over. So I quickly tell you what we came across today in ADR mechanism. First, we have to know the advantages of ADR mechanism. Why we know first what is ADR and why we need ADR, and next what are the advantages of ADR. These things may sound simple. Do attend previous year questions, then only you know how your mind per se is working, and try to write the answers. Next, what is the history, statutes concerning, and section 89 is quite important. You have to mention at least 2 lines about that. And what are the cases usually referred for ADR? And then we are talking about the NALSA. Why do we need NALSA? And the committee's report. What are the articles backing up NALSA? Also talk about the preamble, which promises all types of justice that you have to give. And then we will be talking about what are the aim of NALSA and what are the people who are covered under the benefit for NALSA. Please do remember this. This will help you stand out from other people, because many aspirants will think that NALSA, legal aid, we can write all stories. Who knows NALSA will write about section 12. So you have to write about that. Next, we talk about the pro bono features which is available. And finally, we have seen the structure of the entire NALSA authorities, which is quite important and easy to remember. So we will wind up at 6:30, and next class we will be completing the entire NALSA app. Probably on Monday we'll be having the next session. Okay. Thank you so much. Any doubts you can ask me.
Ma'am, what about the left out Competition Act provisions?
Competition Act just we completed, right?
Ma'am, sorry, I just came 15 minutes late.
Oh, we have completed. Bala sir was there.
Okay, ma'am, I came 15
only
minutes
we
late.
completed.
I had
Okay.
my PCM class.
Oh, all right, all right.
Okay, ma'am.
Please see the recordings we
Okay,
have
ma'am,
completed,
sure, okay,
and then we will do the rest of the our area in the Monday class.
Okay, ma'am, thank you.
Okay. Any other doubts? Everybody understood today's class? Any doubts? Okay, Sadhana understood today's class?
Yes, ma'am.
Okay, ma. We'll wind up. Thank you so much.